Swayam Prabha. Digital India. Educated India.
Dear students, today we are going to understand another philosopher of analytical school whose name is Professor H.L.A. Hart. This professor was also belonging to analytical school, positivist school that we had already learned in the last lecture. So, how this professor who contributed to the journey of positivist school, that we will also try to understand, and how is it relevant today. So, this lecture will be a further contribution to the positivist school of law. Professor H.L.A. Hart, he was a great professor who was born in the 20th century, and he had his studies in different universities, renowned universities of the world, but then he became the professor of jurisprudence in the renowned Oxford University. When he was a professor in Oxford University, he took so many lectures, and thereafter he published a book, and the name of the book was Concept of Law. That book was published in the year 1961. In that book, what he did, that he tried to give a new shape to the analytical school, the theory of positivism, and the Concept of Law book that became a classic book in this field. Professor Hart, he not only debated the topic of jurisprudence with several professors, but also he visited different universities in different parts of the world, and he visited Harvard, and there was a famous Hart-Fuller debate. Fuller was another professor of Harvard, and when he visited there, that debate also became very famous. So, you can just imagine that in the 20th century, when this professor was trying to rebuild analytical school, positivist school, then how much it would have been difficult, and how other professors from different universities, they were also trying to counter and further question his theories. In US at that moment of time, there was another renowned philosopher, Ronald Dworkin. He had also interacted with Professor Hart, and there was also another philosopher whose name was John Rawls. So, that was the time in which Professor Hart was born, and that was a time when he tried to rebuild his theory of analytical jurisprudence. So, Professor Hart, he starts his theory not on the premise of Austinian positivism, but he says that the theory which was given by Austin, which was called that command, duty and sanction, that involved many other things. It was not simply law, but it was also involving psychology, because when he said sanction, the fear of sanction is very important. He says that people, they could not obey the law if they would not fear the punishment, the evil that will be inflicted by the political superior. Now, that means that a person who abides by the law, that person will not abide if there is no fear in his mind. So, this fear in his mind is a result of psychological thing. Professor Hart says that it means that you are involving not only the law or the rules, but also psychology, and therefore it should be avoided. When you say that province of jurisprudence must be determined, now in that case we must try to determine exactly the province of jurisprudence, not which is influenced by psychology, not which is influenced by political science, because Austin had also involved political science. He had said that the sovereignty concept, that should also be understood. What is the meaning of sovereignty? What are the identification marks of sovereignty? So, these were also to be understood, but then Hart differed from him. Hart did not say that we have to look at the political science, we have to look at the psychology, but Professor Hart says that we must try to build a pure theory of law which is based only upon laws, not upon psychology, not upon political science, but upon law itself. So, Professor Hart's understanding was different, and he was saying that let us be pure, let us think purely in terms of law, let us try to think purely in terms of rules, and thereafter he started thinking upon those lines, and he gave his sub theory, that is a part of the basic theory, that is positivism. So, he gave his sub theory, that is called the pure theory of law. Purity is important. When you say that province of jurisprudence determined, when you say analytical school, positivist school, he was also belonging to positivist school, but he says that within positivism, what I will say, that only the theory which is based upon the purity of law, only upon the rules, laws, and that is very important. Now, while giving that theory, he tried to make us understand that what is called idea of obligation. What is this idea of obligation? He said that we can't understand the idea of obligation by only understanding the command and duty and sanction which was given by Austin. He said that it is important to take example, and he gave the example of a gunman. He says that suppose if a person is carrying some gold or some coin, currency notes, and some gunman comes and gunman says that okay, give me this whatever you have, and that money or gold is given by the person. Now, that person is not giving the gold or the currency notes because of the fact that there was a law on it, because of the fact that there was an obligation, but he gave that because of the fear of gun. Now, that is important, where he says that look at the distinction. What is the distinction here? In this situation also, the person gives the money. It seems as if that person is obliged to give the money, and it seems as if he will not give the money, there will be a sanction and the evil is just in front of that person. So, can we say that this is the example of law as understood by the scholars? Professor Hart says no, this is not law. There is something else that we must understand. There is an idea of obligation. Now, in this gunman situation, what he says that, can you say that the person gave the money because he was obliged to give? The answer was no, he was not obliged to give. He gave it because of fear. So, what he says that the idea of obligation, that is different from the earlier idea of command, duty and sanction. When someone is obliged to do something, that is a different thing, and when someone had an obligation to do it, that is a different thing. we must try to understand the distinction between these two assertions, that someone is obliged to do something and someone had an obligation to do that. So, this gunman situation is like a situation that you can say that there was a movie H.L.A, and in that movie there was that very famous statement, "Are o Sambha," and when he says that "Are o Sambha, kitne aadmi the," like that is the kind of fear. He instilled fear in the minds of his own people, and because of that, and then he starts shooting, and then that fear that okay, I would be killed, therefore again his people, they start following the command of the superior. So, that gunman situation, which is given not on the lines of H.L.A movie, but he gave that example because at that moment of time movie H.L.A was not released, and I told you that Professor Hart was not born in our country, but he was born there in Vienna. So, Professor Hart says that this is the difference between the idea of obligation and idea that how a person can give something to other. Now, from there he says that obligation implies rules. The statement that someone has an obligation, that implies the existence of a rule. The idea that someone was under an obligation, that implies the existence of a rule. When I say that I gave something to someone because of having a rule on that, then if I did it knowing that there was a rule and therefore I did it, that is called that I was under an obligation. I was not under, maybe that I was not under the fear of a sovereign, but I could say that because I had the obligation in my mind, I had to do it and therefore I did it. What Professor Hart says, that rules impose obligations when the general demand for conformity is insistent and the social pressure which is brought to bear upon those who deviate or threaten to deviate is great. Look at the concept which is different from the Austinian concept. Austin had said that no, political superiors' presence is important. He did not say that it is the social pressure, it is the general demand from the society that a person must fulfill whatever is obligation, whatever is the rule, and that rule must be followed, and there is a reaction from the society. Now, that is very important because Austin did not give that importance to the society, but Hart gives importance to the society. He says that people follow the obligations not because of the fear of the evil from the sovereign, but because of the fact that the members of the society, they want that the person who is obliged to do something, that person does it, and if that person will not do it, there will be a reaction from the society, and that reaction may be hostile reaction also. Suppose if a person commits a murder of one of the members of the society, now the reaction would be that the person should be given punishment, and the reaction would be that the person did not follow the rules which are there, that no, a person should not kill others. Now, that rule was not followed, and therefore, what Hart says that this is the distinction from the Austinian theory, that it is the social pressure which is important. It is the demand of the society that people must conform with the obligation which are there. the idea of obligation therefore is very important. And what he says, that when the social pressure is not organized, the society may be considered primitive. Now, this social pressure is not, according to Hart, that social pressure is not coming from an unorganized political society. So, he says that again he is in agreement with the political society as was propounded by Professor Austin, when he says that there must be a political society in place. Now, here Professor Hart also agrees with it. He also says that there must be a politically organized society, and he says that if politically organized society is not there, then that demand for conformity of a person's behavior according to the obligation, that will not be there. So, this is also in line with Austinian. So, there are some certain points where he would agree with Professor Austin, and there will be many points of departure from Professor Austin's theory. So, in this slide what we have tried to understand, that he differed from Austin on the point that it is not because of the fear that always people abide by the law, but it is because of the idea of obligation that people abide by it, and that obligation is also because of the members of the society, the reaction of the members of the society. Moving further, what Professor Hart says, that the rules and obligations, in the earlier slide we had tried to understand that obligation implies rules, and here what he says, that rules have two basic aspects. One is called external aspect and the other is called internal aspect. So, external aspect of a rule, what does that mean? Internal aspect of the rule, what does that mean? These we will try to understand in this slide. Now, internal aspect of a rule is the idea of obligation, that okay, this rule is there and I have the feeling that I am obliged to do it, to abide by the rule. Now, that is called internal aspect of obligation. There is another aspect of a rule which is called external aspect, and that is merely observing how others follow the rules. So, that is different, which is called descriptive pattern of behavior. So, external aspect is different and internal aspect is different, but these are the two sides of rule that we must try to understand. And there is no compulsion which is involved in the internal aspect of a rule. You can distinguish from Austin, when Austin said that there is a compulsion involved, that if someone will not abide, the king will come and the queen may come and maybe that political superior will come. Here he says that no, there is no such compulsion which is involved in the internal aspect of a rule. External aspect is that how other people they behave, whether they follow the rules, whether they have also the idea of obligation as the idea of obligation which is there in that member of the society who was performing it. So, in that case, an external observer will observe that what are the deviations by a member of the group from the normal conduct. So, that will also be important, that how many people they do not abide by the obligations. This will become the external aspect of the rule, that rule is there, but there has to be seen that how many people they have this idea of obligation and thereafter they perform it, and how many are those who do not perform it. To make it understand further, he gives the example of red light, and he says that suppose if you go to the red light, you are having your vehicle and you move to the red light. For those persons who are having the internal point of view, red light will not merely be a sign that others will stop. they look upon it as a signal for them to stop. So, it means that external aspect of a rule may be that okay, whether other people they are stopping or not, but if you internalize the rules, then what will happen, that you will stop yourself, because you have known that this is a rule and you are obliged to perform the rule, you have an obligation to do it, and therefore, what you will do, that there will be no fear of someone else, there will be no fear of king, there will be no fear of police, and what you will do, that because you know that this is the rule, and because you know that you have the idea of obligation, therefore, you will abide by it. So, this is how he says that internal aspect of a rule and external aspect of a rule. Rule has two aspects, and when you internalize the rules, it will be very easy for any kind of political society, any kind of politically organized society to make the rules applicable to all the other people of the society. Next is that what Professor Hart says, that when we have tried to understand the rule, obligation, the idea of obligation, what he says, that the rules of obligation itself has at least two varieties. The first variety is called primary rules of obligation, and the second variety is called secondary rules of obligation. Now, primary rules of obligation are those rules which restrict free use of violence, theft, deception and such other crimes. And secondary rules of obligation means, it is little bit difficult to understand, because primary rules of obligation you have all heard about, theft, dacoity and murder, but the secondary rule of obligations are, you have to understand it, because this is different. This is a new thing in the Hart's theory. Hart says that power which can confer rule making, if a political system gives the power on certain authority, that authority can make rules, now that's kind of system that is having the secondary form of obligation, secondary rules of obligation. So, it all depends. So, what kind of how this will happen, this, because there has to be some authority which can confer the powers to someone, and those that conference of power, after that only the rule can be made. So, can this happen in any society, or can this happen in some organized political society? Can it happen in some developed society, legally developed society? So, first of all, we will see this aspect of the society, that how this will happen, but before that we must try to understand that there are primary rules of obligation and there are secondary rules of obligation. And what Hart says is that there has to be unity of these rules in a developed society. If the society is developed, if a legal system is considered to be developed, that means that there is a combination of primary rules of obligation as well as secondary rules of obligation. So, if we abbreviate primary rules of obligation by PRO, P for primary rule, R for rules and O for obligation, and SRO, S for secondary, likewise rules and obligation. So, PRO plus SRO, that will make the modern legal system of our times. So, it means that we have to understand the primary rules of obligation and secondary rule of obligation. We will also only then can understand the whole idea of Professor Hart's theory. Now, in this slide what we will try to understand is that Professor Hart says that primary societies, primary rules of obligations are found in primitive societies. Primary rules of obligation, where can it be found? Can it be found in the developed society? The answer is that those rules, primary rules, are found in the primitive societies. Primitive societies mean what? Primitive societies mean that in that society there will be no new institution. The primitive society will be that where people, they normally live in a way which is, we can call it tribal way in which we can call it simple, collective, some small group of villages, and they have said that okay, this is the way in which they will live. There is no nation at all, there is no politically organized society at all. So, that is called the primitive society. So, in primitive societies, I told you that Professor Hart says that in primitive societies also there are certain rules, there are ideas of obligation, and in primitive societies also people, they do not kill others because they understand that killing is not right, killing is not beneficial, and therefore they are obliged, they have this idea of obligation that it is not authorized, and if they will do it, the members of the society, they will be reacting to it in a hostile way. So, primitive societies have also the idea of obligation, but what he says that there are certain defects in the primitive societies. What are those defects? If we understand those defects, then only we can understand that why should we move further to the secondary type of society where there would be secondary rules of obligation. So, we must try to understand the defects, the potential defects of the primitive societies. Now, there are 3 defects as identified by Professor Hart. What he says that the first defect was uncertainty of rules. Now, what are the rules of that society? In primitive society, where are the rules? What are the rules? Those would be very difficult. You will ask why? Why would it be difficult to identify the rules? Because if you look at the ancient rules, if you just imagine that what might have been the ancient rules in our country, will you say that in those times also rules could be identified easily? That was very difficult. You know, you will have to look at the pages of Shastras, Puranas, Smritis, and then even then the exact, the concrete, the precise rule that you could not find. So, what I was telling you that primitive societies, the first defect will be that rules are uncertain. Where are the rules? If you will say that okay, this is the rule, other people, other member of the society will say no, this is not the rule, because this rule was given by this person and this another rule has been given by another person. So, this will be difficult. There is no certain rule on a particular point, and that is the defect of the primitive society, the first defect. The second defect of the primitive society will be that the rules would be static in nature, the static character of the rules. What does it mean? It means that rules will go on in the same way and it will not be changed, it will remain static, and that rule will be followed for a quite number of times and there is no change in it. Even when the society is changing, even when the politics is changing, even when the government or the economy is changing, even then suppose if there is no such change in the laws, can you imagine that if the laws would not be changed, then what will happen to the growth of different new technologies? So, what Professor Hart had identified, that this is also an important defect in the primitive societies, that you can't say that rules can be changed easily. So, therefore, the rules are static in character. The third, what he says, that rules are inefficient. In the primitive societies, rules are inefficient because when the rules are not observed, what will happen? Whether there are institutions, suppose if a person does not abide by the rule, whether there is a court, that person will go to the court to have the dispute resolved. If those institutions are not there, then what will happen? And therefore, what he says, that rules will become inefficient. Rules will not remain efficient, because to make the rules efficient, what must be the basic elements, that there must be different institutions in place, and those institutions must be given the power to resolve the dispute, and that is not there. So, rules will become inefficient. So, there are three defects what we have seen, and those three defects are clearly identified by Professor Hart. At the same time, when he says that there are three defects in the primitive rules of obligation, primary rules of obligation, at the same time he says that these defects can be removed also. Now, he suggests solutions. When he has identified the problems of the primary rules and the primitive societies, he also suggests that the problem can be solved, and how that problem can be solved. For that, he says that we can solve this problem by having secondary rules of obligation. And secondary rules of obligation, that if that is present, then the society will be considered a modern legal society. Then the legal system will be considered as a modern legal system. So, what are those secondary rules of obligation, and how can those defects be removed by those secondary rules of obligation? Now, there he says that in the secondary rules of obligation, the first thing which will be there will be the rules of recognition. Now, what are those rules of recognition? Rules of recognition means those rules which will recognize the laws which are there. Now, if these rules are there, suppose for example, take the example of a statute, laws. We say Hindu Marriage Act, we say Indian Contract Act. Now, how can we say that this is the law on the contract? How do we say that this is the law on the marriage? Because this is codified in a particular place. All the rules, all the laws on Hindu marriage, that is given in one particular place, that is called Hindu Marriage Act. Likewise, if you talk about crimes, different crimes, the punishment, that is given in the Bharatiya Nyaya Samhita. So, this is how you see that, but rules of recognition, how will you say that these are the rules which will apply? Now, it means that there will be someone who will say that no, these rules are recognized by the authority, by the competent authority. So, if these rules of recognition are present, then that is a society which is a developed society, which is a legally mature society, which is called, we can call, there are secondary rules of obligation there. The second is that rules of change, and this rule of change will remove the second defect of the primary rules of obligation society, in which we had said that static, the rules are static in primitive societies. Here what Professor Hart says, that this defect can be removed by having those rules which we will call rules of change. Now, what are those rules of change? Rules of change will mean that the competent authorities or the legislature can confer the powers upon some institutions that the laws can be changed. So, this is how laws can be changed, and if it is a smooth change, if it is easy change which is possible, that is a very good thing. It means that to change a law there need not be a revolution. Without revolution you can change the law. That is very good. If that system is there, if that system is in place, it means that the society is a developed society. That society is called that society where there are secondary rules of obligation. So, the second important thing is that in a secondary rules of obligation society, there will be rules of change also. Third, look back at the third defect which was identified by Professor Hart. He had said rules, even if there are certain rules in the primitive societies, but rules will be inefficient. Now, why he was saying so? Because he would say that suppose if there would be a dispute, where the people will go? If there is no court, if there is no system in place, if there is no institution in place which can resolve the disputes. So, what he says that there would be the solution of this problem. And what is the solution? Solution lies that in the secondary, in the developed societies, there would be rules of adjudication also. How a particular dispute can be resolved through adjudication. So, this is also there, this is present in that society where there would be secondary rules of obligation, where there is not only primary rules of obligation, but where there are secondary rules of obligations too. So, in this slide what we have tried to understand that if there are only primary rules of obligation in a society, that society will remain static, the rules will not be efficient and the rules cannot be changed. But if a society which is also having secondary rules of obligation, in that society these features are also there. There will be a system of adjudication, there will be rules of adjudication, there will be rules of change, and also there will be rules of recognition. And these are all institutionalized, these are all in place. So, what will happen that there will be no revolution to change a law, there will be no bloodshed, there will be no violence on the streets, and everything can be done smoothly. So, this is a great change from the Austinian approach on the positivist school. Thereafter, what he says that the rules of recognition, because I have told you that there are three things you have to understand. First are rules of recognition, then there will be rules of change, and then there will be rules of adjudication. So, let us try to understand one by one in the slides. Now, first is the rules of recognition. Now, we have already understood that rules of recognition is the secondary rule of obligation. Secondary in the sense that this is the example of the developed society where there are rules of recognition. So, what is the meaning of rules of recognition? Earlier, just by way of little bit of just introduction I told you, but these rules are used for identification of primary rules of obligation. So, primary rules of obligation mean that what are those rules, how can we identify that this is a statute, how can we identify that this is a codified law. So, now this will say that okay, if a particular law has been moved in the parliament, if the draft bill was moved in the parliament and thereafter it was debated, discussed, if thereafter it is passed and thereafter it is notified, gets the assent of the president, all these processes are already given, then you can identify that okay, this is the rule. Now, this is called the secondary rule of what we call rule of recognition. And here you will find that both private persons and officials are provided with authoritative criteria for identifying those primary rules of obligation. So, you see that private persons the question will be, can private persons be given the power? The answer is yes, why not? Can officials be given the power to identify the primary rules of obligation? The answer is yes. And how do we do it? This is given in this slide in a circular form, and you will find that sometimes if there is a reference to an authoritative text, so you can say that okay, this rule is there in that authoritative text, then and if your rule permits it, that you can go to that place. You can see legislative enactment, law has been passed by the legislature. You can also see the customary practice, but then customary practice has to be recognized by the present political system, by the present system of governance. Then the general declarations of specified persons, what have been declared by certain eminent personalities, and past judicial decisions in particular cases. So, this is very important, like suppose if you do not say that judicial decisions of earlier times, if they will not be given any place in a society, it means that the society is not a secondary obligation based society, secondary rules of obligation based society. So, what we have to understand is that there are rules of recognizing, rules of recognition of the laws. So, what are those rules? If those rules are already made beforehand, not that when the rules are made after that, beforehand you have the institutions in place, that you have already made the institutions which can identify the rules, that okay, this is the relevant rule for this case, and that may include the judge made law. So, here you can find difference between the earlier discussed Austin, where he said that no, I am not recognizing the judge made law, but Professor Hart says that past judicial decisions in particular case, that is also a rule of recognition. So, you can say that okay, we can recognize this as a law. So, what does it essentially mean? Essentially it means that you know what are the sources of law, you know that where can you find the law. So, in the secondary rules of obligation based society, what will happen, that in the society there will be clear cut written rules about the different sources of law. In that society, maybe that written rule may say that we have put our greatest faith in the written constitution. And if that is so, it means that that society has recognized the written constitution as the highest law of the land. In that case, you have recognized the rule which is the highest rule. So, this is the rule of recognition. These are some of the examples of rules of recognition. If those are present in that society, it will be a much better example of the society which is a developed society, legally developed society, where there are secondary rules of obligation. Further, he talks about the validity and efficacy of rules. We might be confused by using these two words. What is the difference between validity and efficacy? Are these two words not same? The answer provided by Professor Hart was no. He said efficacy of rule is different from validity of rule. How do we test it? How do we say that validity of rule, where can we find, where can we test it, where can we say that efficacy of a rule is this? Now, for that he says validity of rules are given in the sources of law. It means that suppose if I say, if I give you the example, if I say just okay, the statement made by Mr. X is a law, and if I ask you to answer the question whether you consider that statement made by person A will be law, what will be your answer? Will you say that this is a law? And if you say yes, you will have to give reasons. What will be your reason? Will you say that no, because I think? That will not be the correct answer. That you will have to say that whether the rules recognize the statement made by A or X as a rule, and then if there is a rule regarding this, then it can be said that this is a rule. So, what Professor Hart says, that rule of recognition must be there, it means that the sources of law must be there, and thereafter you can say validity of rules. So, if you say that okay, this rule is valid, it means that this rule is recognized by the rules of recognition. And then he says validity. Validity of law is not the same, as I have told you. And efficacy, what is efficacy? Efficacy, he says, that a rule of law which requires certain behavior which is obeyed more often than not is efficacy. Now, efficacy does not mean that every person will abide by the rule, whichever rule is given. Efficacy does not mean that 100% people they will abide by a particular rule, but efficacy of rule will be that more often than not, if a rule has been obeyed, that means that the rule is efficacious, rule is efficient. Now, what is the meaning of more often than not? Now, it is again a little bit of worrisome word. It is a general kind of word where you can say, so you can say that more often than not, it means that normally it is obeyed, generally it is obeyed, but yes, always you can't say that the rule is always obeyed. You can't say that every member of the society obeys the rule, that is also not the case, but you can say more often than not. So, he cleverly used these words, more often than not. If a rule is being adhered to by a member of the society, it means that rule is efficient, rule is efficacious, and therefore, he says that you can differentiate now that whether a rule is valid, that the test will be different, whether a rule is efficacious, the rule will be different. It is not the same rule. The rule of validity will be the sources, the rules of recognition, but rule of efficiency, efficacy, that will be different, what we will call that how many people abide by it, whether it is being abided by the most of the people. If that is so, the rule is efficient. So, this is how you see that Hart tried to understand, make us understand that what are the differences between these two different types of rules. Now, next, which is very important for Professor Hart, was ultimate rule. Now, when it means that he categorized rules, we have seen that primary rules of obligation, secondary rules of obligation. Then he talks about the ultimate rule. What is this ultimate rule? Now, he says that this is the ultimate rule of recognition, rule of validity. He says that it is a rule of recognition providing the criteria by which the validity of other rules of the system is assessed, ultimate rule. Further, he says that even if ultimate rule is in conflict with other rules, ultimate rule is still valid. And in this pyramidal structure, you will find that in the primitive society there is no rule of recognition. In the secondary society there are rules of recognition, and in the secondary or in the civilized societies there are ultimate rules of recognition. So, ultimate criteria of validity, suppose if a statute is tested whether it is valid statute or provision of the statute or not, then what can be done? Is there any ultimate criteria of validity laid down? And if the answer is yes, then we have to go to that criteria. In our country, for example, if we have to test the validity of a particular given law, where will we go? Whether we have some ultimate criteria of validity mentioned in any instrument? The answer is yes. We have the constitution. So, the validity of the statutory provision, that will be tested by ultimate rule of recognition, by the rule which is given in the constitution. So, therefore, what we say that in our system, in our country, there is also ultimate rule of validity, ultimate criteria of validity. But in those countries where there is no constitution, where can you find the ultimate criteria of validity? There also you will have to find, and there you will find it in the judicial decisions, which is called highest kind of practice, common practices. So, there you can find that the ultimate criteria is given. So, he does not say that okay, because people are not abiding without fear, they cannot abide, therefore, rules are inefficient. No, no, no. Again the rules will come. Whether a rule has been not abided by, all these problems can be checked when we only study about the rules. Finally, we have to evaluate. We will take some moments to evaluate what was propounded by Professor Hart. Now, if we look at the notion of rights, you will say that Austin theory did not take into account the notion of rights, but Hart's theory explained it. What was the notion of rights? Now, individual rights. In the last lecture I had told you that can a person make a will? If a will can be made by a person, then that is also recognized by law. In the last lecture we have seen that if a contract can be entered between two parties, can it not be a law? So, these are the rights of individuals. Austin's theory did not give due importance to the individual, he gave importance to the ultimate role of the sovereign. But Hart's theory explained it. Hart says that power can be conferred upon individuals by the competent authority. Thereafter, we can say that Austin did not consider the conferment of powers to even the judiciary, members of judiciary, but the reality is that power can be conferred upon the members of judiciary to adjudicate the disputes. As you can understand that there are lakhs of disputes which are pending, and how can those disputes be resolved? So, unless it cannot be resolved if there are no power conferring rules. And then he says that the union of primary rules of obligation and the secondary rules of obligation, those are also very important. And more importantly, he further says that international law is not merely a positive rule of morality, but it is law. And but Here again he says it's an example of only primary rules, because international law does not have secondary rules of recognition. So, here again he goes a little bit more, what we said, in a developed form. He says that international law is just example of primitive rule, but he says at least international law is having the character of rules. And one of the professor of US, Dworkin, Professor Dworkin, he says that law is not simply a system of rules. The importance of principles, standards and policies cannot be understated. Legal doctrines of unjust enrichment, presumption of innocence. So, it means that what he says that, because Hart relied only upon rules, Hart relied only upon the laws and laws of recognition, etc. But what Dworkin was saying, that this was just a limitation, because law may include also principles and doctrines. So, what we can understand that Professor Hart, although he gave a very good justification and developed the theory of Austin in a different way, but still he had also certain shortcomings. So, with this we have tried to understand the developments in the positivist school of jurisprudence, in the what we call pure theory of law, and we have also tried to understand that how his theory was different and how did he explain it differently, and finally we have seen that what are the shortcomings of Hart's theory. Thank you so much for giving your attention to this lecture, and have a great day. Thank you.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.